Hello friends, I am very happy to talk to you in this video, and I understand that all of you are military lawyers or those connected with the military law, and I am talking to you with the view for your professional development. Since you are intimately connected with the Judge Advocate General's department, that's in short called JAG department, I would like to tell you that this department or the segment of the army was the last portion of Indian Army that was Indianized, and it took place only in 1945. So therefore, while the officers had started being commissioned in the infantry sometime around 1920s or earlier, but it was only in 1945 that when the Britishers knew that they have to leave India shortly and India would attain independence, that they accepted the first officer, that time Captain or Major D.M. Sen, who later became the first Judge Advocate General of Indian Army and was also after his retirement elevated as a judge of the Assam High Court. I would also like you to think that this department, Judge Advocate General, it has three significant words: Judge, Advocate and General. Now, why is it called Judge Advocate General? Firstly, they are never as a judge alone, although in certain other armies like American Army, an accused has an option that he can want to be tried by the military law officer sitting as a judge alone. They are advocate in the sense that they advise the commanders who's their client, the army is their client, but most significant part is general, that comes in the end. That means that a person who may act as a judge or advocate must never forget that he is a military officer. General is a military rank. And even though in the days, decades and centuries before, when the JAG was only of the rank of colonel or brigadier, this word general was there, which denotes the ultimate in military hierarchy, and it conveyed a sense that a JAG officer shall be an epitome of military leadership. Now, it is an expectation by virtue of the word general that the cadets, when they are selected by the Services Selection Board, the board does not, the GTO or the president or the psychologist does not ask questions relating to military law. It is expected that the candidate who comes there must possess officer-like qualities, OLQ, and adhere to a conduct which is expected from a military officer. And it is often said, they say that once you have a law degree and you are qualified to be fully in position to be practicing as an advocate, that's good enough. Military law we would teach you, but we expect that you should possess officer-like qualities. I would also like to take your attention to the functions or the role which a JAG officer performs. Traditionally, in the British Army prior to independence, a JAG officer's sole job was to help in rendering advice for maintenance of discipline. And he acted as a judge advocate at the trial or rendered pre-trial or post-trial advice. He also carried out training that was in relation to military law, that was part of the curriculum for Part B, Part D examination, and also entrance examination for the Defense Services Staff College. So the functions of a JAG officer at that time related to trial, that is maintenance of discipline or enforcement of law, and secondly, training in military law. But later, after we had attained independence, the function included advisory. It can also be said that for a British officer, what he said, a commander or a general, that was law. That was the command that was expected and that was to be obeyed. So really there was no advice sought. If there was some lack of clarity or clarification needed, one went back to the commander and sought the further instructions. And in any case, no court would have at that stage expected a petition or a complaint with regard to a military decision, and there was no litigation. You would see that regulations for the army, which is known as Defence Services Regulations, para 33 relates to the Judge Advocate General, and it says that JAG is the legal advisor to the Chief of Army Staff in matter of military, martial, and in its fighting service aspect, international law. So the point to be made is, to be noted is that JAG is a legal advisor. To whom? To the Chief of Army Staff. Further, the next sentence says he assists the Adjutant General in matters relating to discipline. Now, the Adjutant General in those days was expected to enforce the discipline, and the office of the Judge Advocate General, which only had officers, there were no JCOs or other ranks then or even now. They were a part, they assisted the Adjutant General, but they were not under the Adjutant General. It was located in conjunction to the Adjutant General's branch. And those days, the JAG, even though he was a brigadier, his confidential report, his performance was adjudged by the Chief of the Army Staff, who was could have been a full-fledged general or even field marshal. So bear that in mind. You would see that a judge advocate, this is also pertinent, that at each trial he takes an oath. You all know that. And the wordings, the text of that oath, you can see on the screen in front of you. But the point I am trying to make here is that a judge advocate at a trial, right at the start, before the commencement of trial, takes oath in a similar manner like it is done by the members of the court or those under officer under instruction or a shorthand writer. This is not what happens in a court of law, whether at a district court or a high court or at the apex court. There, a judge does not take oath before every case. Now, why is this so? This is, to my mind, has been included in the rules and in military law procedure to remind the judge advocate, the officer who has come to perform those duties, that he is thereafter carrying out the duties in relation to the court-martial. So like a member is cautioned when he takes the oath, he is reminded, in the same manner the officer who till the previous day may have been part of the Deputy Judge Advocate General at the command headquarters or corps headquarters is cautioned. He is reminded that henceforth, for the duration of the trial, he would be carrying out the duties of judge advocate. You may also wish to take your mind to the law of armed conflict, which you are aware is based on the 4 Geneva Conventions and additional protocols there too. In particular, think of Additional Protocol 1, Article 82, that concerns legal advisors in the armed forces. the article states the high contracting parties at all times and the parties to the conflict which is taking place shall ensure that legal advisors are available. Now, naturally, legal advisors can't suddenly spring up during war. They have to be there during peacetime. And they are available whenever it is so necessary to advise military commanders. It is their duty to render opinion, advice to the military commanders, which is at the appropriate level. It has not been indicated. So therefore, if required, a legal advisor may be at the army level, it may be at a corps level, it may be at a division level, brigade, and Western armies, I'd like to tell you, and in NATO forces, there are JAG officers available, provided even at a battalion or at a unit level. They advise how the conventions and the protocol are applied to a given situation. Together with rendering this advice, they also carry out rendition of appropriate instruction. That means teaching to the members of the armed forces at various levels on this subject. Apart from what you saw just now as part of Additional Protocol 1, there is also rules of customary international humanitarian law that have now attained the status of statutory law. Now, Rule 141 there pertains to legal advisors for armed forces, and it states that each state must make legal advisors available. It is obvious, therefore, that this obligation is at the state at the highest level, that this requirement of manpower has to be met. They should be so available that whenever it is required or necessary, they come up and give advice to the military commanders, again at the appropriate level, as to how the international humanitarian law, which is also known as law of war or law of armed conflict, LOAC, is to be applied. And this relates to methods and means of warfare. And ICRC, International Committee of the Red Cross, which has its head office or its base at Geneva, is concerned with this IHL. Spring forth from the Geneva Conventions, additional protocols, and the customary rules of international humanitarian law. Therefore, there are duties which become obvious under the operational law for the practice by the JAG officers. They have to undertake role of advisory, they render the advice, they give the training. The training can be theoretical classroom, it can be in a clinical mode, and thereby they ensure, it is their duty, that compliance to IHL is there, and this in turn means that all ranks should harbor no doubts or lack of clarity as to what is their duty, what are they expected to comply. In case there is difficulty in understanding the relevant provision of law of armed conflict, then they carry out interpretation. And if the military advances or for certain duration of time is in occupation of a civilian area, then the difference between the military and civilian population, and so as to the civilian administration or the civilian population is suitably ruled, administered. This work is also carried out by the operational law officers of the JAG, and in any case, all this means that the military discipline during the currency of the warlike situation is maintained. Having seen these provisions, you may wonder as to what is to be done by a JAG officer and what he is not required to do. In other words, do's and don'ts. We will spend some time on that. As regards do's are concerned, a JAG officer must remember that he is expected in his domain to attain professional excellence. Law is never static, warfare is not static, the nature is changing, and it is expected that the officer would display total excellence with regard to what he is expected from him. In this regard, I will take your mind, I'll recall a video that I had made while speaking to Mr. Fali Nariman, perhaps arguably one of the best lawyers in post-independent India, and this video related to his advice to the young advocates. And while telling them as to how they should prepare a particular case which they are required to argue before a court of law, Fali Nariman said that every case has three dimensions or three sides. The first is the arguments or the facts and law which a young advocate or an advocate, not only young, any advocate plans when he is preparing for appearing before the court on the desired date. The second set is what he actually presents to the court when he gets up and gets an audience in the court of law. And very important, the third set of argument or the version is what comes to his mind later when he comes out of the court or at night when he goes to bed, that he feels, oh, I should have argued this. So we have to, Fali Nariman made it clear that even at the age of 92 when he was speaking to me, he says that this dilemma comes before him when he has to go and prepare for a case. Apart from professional excellence, the JAG officer has to display and maintain highest level of integrity. You are aware of the Chetwood credo that is there at the Indian Military Academy on their drill square, which states that the safety, honor and welfare of your country come first, always and every time. The honor, welfare and comfort of the men you command comes next, and your own ease, comfort and safety come last, always and every time. Now this is not to be forgotten, and this carries an indication to integrity, ethics, honesty and respect, which all are contained in the term integrity. And a commander said that what we need today more than anything else is the moral leadership founded on courage, intellectual integrity and a sense of values. Now these sense of values are never to be abandoned. Linked with integrity is the notion of discipline. You have here a picture of Nani Palkhiwala, who had said that the acceptance of indiscipline is even more disastrous than indiscipline itself. In other words, that indiscipline is never to be tolerated because it can have disastrous consequences. Apart from integrity and discipline, there is a need that opportunities must be seized and must not be lost sight of. For this too, I have a quotation by Nani Palkhiwala where he said opportunities multiply when they are seized. That means the point is you have to seize an opportunity. They die when neglected. And moving on, Palkhiwala said, I am not the type of man who complains of noise when opportunity knocks at the door. Another instance of grabbing an opportunity, I would like to give you a personal example. I was the Judge Advocate General at the Army Headquarters when President Kalam was the President of India, Professor Kalam. And one day I got a message from one of his key advisors who was known to me, and he said that the President was scheduled to make an address as the chief guest at Vigyan Bhavan at a meeting, at a seminar of top judges and senior advocates. And he expected me to write a draft speech for the President. I was perplexed to begin with, but then I had no choice. I did that. And I also had an invitation to attend that function at the big hall of Vigyan Bhavan. And to my great surprise and pleasure, I found that in the President's address that Professor APJ Kalam delivered, my advice to him or my suggested text sent to him was suitably included. So it is not with a view to blow my trumpet that I am recalling this incident. I am just trying to impress upon that whenever an opportunity comes, grab it. You can't you have no other option. A lawyer, including a military lawyer, has to be an effective communicator. And this communication is both with regard to oral communication and written. As far as oral communication is concerned, I have put on this slide a picture of Nani Palkhiwala, who by any reckoning was a superb communicator, inside court or outside. Now what it involves, what are the significant features, components of oral communication, is that it should be simple, which the audience at that particular time should be able to clearly understand. One should be fluent, it should not be jerky. The words, the way they have been used, and the sequence, they must carry clarity. They should be well connected like the links of a chain. They should be delivered with modulation, with rise and particular emphasis, etc. when needed. And lastly, but not the least, they should be spoken with confidence. Therefore, ladies and gentlemen, when you as a legal advisor are in front of an audience, it could be a meeting with the commander who wants your advice, or you are taking a class, or you are a judge advocate, any occasion, the oral communication, you have to prove your competence. And the list there in front of you is Palkhiwala's speech that he gave at Loyola College in Chennai in 1971 on an occasion when he was called upon to speak on 24th, 25th and 26th amendments to the Constitution of India. It is an education if you hear Palkhiwala speaking. Apart from oral communication, equally important is written communication. Quite often you would come across that in a judgment or in a textbook, elsewhere in a written brief, there are long sentences running into 3, 4 or more lines, and one has to read it many a times to understand it is, to find out as to what is being said. Contrary to that, please practice and acquire a capacity to write simple, effective, logical and short prose. There are a number of examples. Mahatma Gandhi's English, or you read Bible, it is said biblical language. It should be easy to understand, and it should not be verbose. All unnecessary words must be totally eliminated. Just to illustrate as to what is brief and precise prose, I have written down of certain well-known persons from their writings. Mahatma Gandhi said, facts mean truth, and once we adhere to truth, the law comes to our aid. Palkiwala has written at place and very many times in a similar manner, no city, no democracy can survive without law and order. Mr. M.C. Chagla, Justice M.C. Chagla, who was Chief Justice of Bombay High Court for many years, he wrote, people are apt to romanticize their childhood. Justice Hidayatullah, former President of India and Vice President of India, wrote, after Bose left, the court received as Chief Justice B.P. Sinha from Patna. And Soli Sorabji, the eminent lawyer, wrote, doubts however lingered about the legal status of the declaration. I would also like to remind you that there is a need that JAG officers should be provided opportunities to serve in staff and at other places, not merely on JAG appointments, but in other appointments, for example, Brig A at a command, or a DDG, DV, DDG PS, Provost Marshal, very many posts. But for that it is important that they are provided opportunity to attend courses like Junior Command, Senior Command or Defence Services Staff College, courses at short duration or long at College of Defence Management, and finally at the National Defence College. Now, this demand has to emanate from you, ladies and gentlemen, and the seniors have to work in that direction. It is also necessary that as part of forward and backward integration in the corporate, you also should specialize in connected laws. And connected laws, I have written few examples just to highlight. For example, operational law that deals with military deployment and undertaking military missions with regard to Offshore Secret Act or Prevention of Corruption Act. Administrative law, so that the decisions taken by commanders are not challenged, and the aspects relating to disability, space, sports and arbitration law. I'd like to tell you that more than 3 decades back, I had an occasion to go and visit in Netherlands the University of Leiden. And when I went to their law faculty, I was pleasantly surprised when I was told that they were offering a LLM program in sports law. And they told me that sports games like tennis or boxing or golf, etc. have huge money, and they have legal aspects, legal issues, legal problems, and therefore they were offering a LLM program in sports law when no university in India at that point of time had thought of it. One would need, and it is the demand of the hour, that role of the Judge Advocate General's officers is expanded, and just to indicate a few areas where there is a need for increased participation could be in tri-service operations. It could relate to administrative law, including in the military secretary's branch, and the related, record officers for the occupied area governance, for more than 3 months, that, for example, when Indian Army was there in Bangladesh, after the defeat of West Pakistan and surrender of the West Pakistan army. It may be required in peacekeeping operations or peace enforcement operations, in the administration of military cantonments and military stations, in matters pertaining to procurements, armaments, their procurement and trial, etc. Also cases of, say, misfire and accident, and in matters like arbitration and mediation. And on right you would find that some of the offices where JAG officers may be needed is also indicated, including Office of the Legal Advisor, Defense. Also, there is, to my mind, a need to enhance tenability of JAG officers in Tri-Service Commands and National Security Council Secretariat. There are different issues relating to human rights and Armed Forces Act on disability, etc. Then in the Office of the Defense Land and Cantonments, those labs and factories where weapons are produced, ordnance factories relating to international humanitarian law, and even in a number of institutions of army welfare, education, society. This would have made it apparent to you that the text of different laws which military lawyers handle should be clinical in nature when it is to be taught. Merely a classroom lecture will not suffice. The students have to apply that law and they should be trained to acquire that skill. For example, framing of a charge sheet is a skill. The role of a judge advocate general or role of a judge advocate at trial is a skill. So, law teaching should be in clinical mode at the Institute of Military Law. The other training establishments where military law is taught as a compulsory or optional program, like at Infantry School, College of Combat, Military Intelligence Training School, Army Medical College and Center, they have an OTS there, Officers Training School. There is a need for JAG officers to undertake this military instruction part at these category A, B establishments. There is a need that intelligence officers and others should be taught in courses pertaining to interrogation, cordon and search, drawing and operation of contracts, etc., the legal aspects, and also at Army Institute of Law and the Army Law College. Further places where military lawyers may be invited to teach includes universities and law colleges, at category A and B training institutions, think tanks and civil society, at faculty development programs at different institutions and national and state human rights commission. Military lawyers would also be expected to provide assistance in regular revision and updation of rules, regulations, order, instructions, etc., so that they meet the need of the hour. Insofar as revision or updation is concerned, it is needed in the Defense Services regulations for the Army. Just to indicate few areas, for example, the Chief of Defense Staff, his office, his role, duties, cyber warfare, the regulations are silent, and they don't say anything, they have no provision, no para to deal with women officers, Army instructions, human rights and environment. And certain don'ts which are not to be done, having seen the do's. Firstly, never procrastinate. There is a saying that if you keep doing what you have been doing, you will keep getting what you have been getting. So if you want to advance in career, you want to rise, you want a promotion, you have to do something more than what you have been doing. You also have to be frank, prompt, and clear. I think, to my mind, I think, go back to one of the assistant judge advocate generals at a command. It was famous, it was said about him that when juniors went to him for any advice, and he used to talk irrelevantly for minutes longer and then send them away with the remarks merely "dekh lijiye." He never gave a clear advice. Also, there is a need that you cut down trivialities, things which are unnecessary, which have no sort of implication or bearing on the task at hand. And just to illustrate, also some other situation, for example, if you are dealing with a case where a material witness is not forthcoming, then rather than coming to a standstill, you think what happens if he is just not there, just does not come. Can the trial, can that matter be left? Or I would like to tell you that when we went as judge advocate at trial, when I was a captain and major, we were given clear orders by the Deputy JAG command. We had Colonel, later Brigadier Mangla in Central Command, and he used to insist that every day we were expected to record 10 pages worth evidence. And he says that an incidental question is not evidence. He says if it is not there, we should not expect payment of any daily allowance, TADA. Now that sort of strict norms have to be enforced. Lastly, I would like to tell you, ladies and gentlemen, that now I am making YouTube videos, and there are also videos that I have made on matters pertaining to military, wars, on law, on military law, legal education, and the one is especially directed at teachers, to be good teachers in law. So one video is released every day at 11:45 hours. If you are interested, you would benefit and you may like to view. In conclusion, I would like to highlight that there are changes taking place in methods and means of warfare at different places, whether it is Ukraine and Russia, whether the war at Gaza, Israel, Iran, or our operational Sindoor. And these changes put pressures on governance. They put up issues relating to human rights regime. There is an increasing oversight by the judiciary and changing methods and demands of international relations, which all add up to expect that the JAG officers perform the duties and the functions that are given to them by their commanders. I hope you would benefit by this presentation. Thank you.